So welcome to our webinar on the Community Justice Worker Proposal. My name is Zach Newman. I use he, him pronouns, and I'm the directing attorney at the Legal Aid Association of California, or LAAC. I think most of you probably know LAAC, but we are the membership organization for over 100 legal aid nonprofits in California, for whom and alongside we provide training, coordination, and advocacy to move the needle on providing civil legal aid in California. Before we get into the panel, I wanted to do some brief table setting before we jump in. As many of you know, last year, LAAC convened a working group of leaders from legal aid nonprofits in our state to explore the potential for a CJW program here in our state. This, of course, culminated in a robust proposal based on the discussions held over the course of 6 or so months that examined and dove into what a framework could look like for a CJW program here in California. Hopefully many of you have gotten a chance to review this proposal at least a little bit, but our panel will be covering some of the basic workings of it today too. The working group was led by some of these folks, Legal Link and OneJustice, with advice and support from Stanford Law's Center on the Legal Profession, as well as Frontline Justice. And so today we have Sasha Steinberger from Legal Link, Lee Farron from OneJustice, and Dana Alpert and Lucy Rica from Stanford on the webinar. And we're also lucky to have a couple of members from the working group, Diego Cartagena of Betzedek, as well as Jessica Jewell from CRLA. So in terms of the panel, we're going to get started with describing the background of this issue and some of the solutions around the country, cover what the actual proposal is, and then get into some of the regulatory issues surrounding CJWs. In terms of a little bit more housekeeping, this is a Zoom meeting and not a webinar. So we're hoping that we can do some Q&A and discussion at the end. So please save your questions and thoughts until then, and we can have a facilitated discussion. So thank you, everyone, for being here today. Sasha, do you want to take it away with the first section of the webinar?
Yes, thanks, Zach, and thanks to LAAC for hosting us here today to talk about our CJW proposal, a community justice worker proposal. As Zach mentioned, I'm with Legal Link. We're a Bay Area nonprofit. I am going to start. Oh, it's a lot of screens we are seeing. I like it. Lots of folks here today. I'm going to start to talk a little bit about the problem. And everyone on this webinar, I'm sure, knows the problem, is very familiar with the problem, but just to get us all on the same page. As we know, less than half of people seek out legal help when they're faced with a legal problem. That includes legal help, might include courts, private attorneys, legal aid. Less than half of people seek out that help. And of those, the most recent California Justice Gap study found that our legal aid organizations can fully help just 30% of those who get to them. So what this means, of course, is that lots of people are not getting the help they need. And the estimates are 85 to 92%, depending on the study you look at, of people are not getting the full legal help that they need. So in addition, as we all know, funding is tight. It's more complicated now than ever. And trust in the legal system is low. So we know this, the data shows this, and anecdotally at our Legal Link trainings, we hear it in every training that we give to community partners. And we also know that people are already turning to trusted family members and community leaders and medical professionals, sometimes as often as they turn to legal folks. So this is where community justice workers come in, where the model comes from. It comes from thinking about how to extend our resources to do more and to tap into trusted community members who want to help, but don't have necessarily the training, resources, or support they need to do so. And there are lots of ways to engage non-lawyers. If you don't have regulatory reform yet, like in California, then the options are slightly more limited. A lot of you at your organizations probably are engaging with non-lawyers all the time with Know Your Rights trainings, partnerships, MLPs, and other programs. The community members play an important but very much supportive role in most of those programs. At Legal Link, we've built out a legal first aid training program to help train frontline providers at local nonprofits and how to identify, refer, and support people with legal issues. they are often able to help resolve issues in a pre-legal space before they become crises and before they get to the courts. In Arizona and Utah, where they have regulatory models that allow for it, there are programs that train non-lawyers to help with discrete legal services. So, for example, victim services advocates in Utah have been trained to provide advice on DV restraining orders and are having remarkable success at teaching folks who otherwise wouldn't have had access to legal help. At Alaska Legal Services, there are community justice workers who are spread far afield across a large and not very populated state. They're focused on SNAP, or, in California, CalFresh, wills and consumer issues. Again, these are all services for folks who would otherwise have a very hard time accessing legal support, or definitely accessing trusted legal support. So how do these programs work? These allied professionals are typically people who don't work for the legal organization, but they are trained by them, they're covered by their malpractice, and they help on discrete legal issues for qualifying clients. They are just like a pro bono attorney without the attorney background. Knowing that these models have been growing up across the country, we wanted to figure out what would work in California. So as Zach mentioned, LAAC convened this working group. Some of you may have been on a webinar we did about a year ago as we were just heading into that project. We had representatives from 12 different legal aid organizations from across the state. And we're really excited with the project and the proposal that we came up with. So as Zach mentioned, Lee and I led the group, and Lucy, who you'll hear from, and Dana from Stanford, provided invaluable support, and Nicole Nelson, formerly of Alaska Legal Services, now Frontline Justice, also advised. And we also have some working group members here with us today. I know Diego and hopefully Jessica as well. And I'm just looking through names to see if there's anyone else. If you are here, feel free to jump in when we get to the discussion. We want to hear from folks. So that's the background on how we got to the proposal, and I'll pass it to Lee to talk more about what we came up with.
Thank you. I'm going to share just a few slides because I think it will help with some of the details. But so I think Sasha, the spotlight is, it's a little intimidating, I'm not gonna lie. So I think that before I share the slides, as Sasha said, we spent a number of hours meeting with folks and really looking at what folks are doing in other places and coming up with what we thought would work in California. At the same time, we also really want this to be a proposal that is flexible and works for legal services orgs in California. So I think we all, or I at least want to just be clear that this is a proposal, right? And there's like components that may work for what you're thinking about, and there's some that may not. So while we're talking through them, as Zach said, like start thinking of your questions, and we're happy to kind of engage. And that's what we've been doing since the working group finished up, is really engaging with folks to get their thoughts. And as a result, like some of our thinking about what may actually work has changed a little bit. Okay, so let me now actually do what I said I would. Okay. Maybe. Okay, there we go. It should come up in just a minute. Okay, so the first thing that we talked about is what exactly a community justice worker is, and how they would kind of fit into the ecosystem of legal services orgs and everything. So a community justice worker is a person who would not be licensed by the state bar, but they would satisfy training and other requirements that would be determined by an authorized legal services organization. So the way the program would work is that the legal services organization would obtain authorization to host community justice workers. And then the community justice worker could engage in the limited practice of law exclusively for that authorized legal services org. And to become an authorized legal services org, we propose a streamlined process for groups that are already funded by IOLTA. We all know the kind of analysis and evaluation that you all go through. And then there would be a more robust application for any non-IOLTA funded organization. I think it's important to kind of note here that because the person is not licensed by the state bar, that the kind of the burden falls on the legal services organization to identify who their community justice workers would be and who they would choose to partner with. In terms of the education and training of the community justice workers, legal services orgs would be responsible for developing the training plan, including specific curricular components and experiential learning. The training should also include the ethical provision of services. The goal is to create some broadly applicable training. So I think this piece of it in particular, I think could sound overwhelming to legal services organizations, but with the expertise of folks like Legal Link and also Frontline Justice and others that have stood up programs in other states and kind of have an idea of what kind of training and experiential learning is most beneficial, I think there's an opportunity to create some statewide components to this training. I think where the legal services organization would bear more of the burden would be in the particular law that the community justice worker would be practicing, especially as to any sort of local aspects of it. You know, I know people could go to general, when I was in practice doing consumer law, people could go to general consumer law trainings, and then we would tell them how the particular judge they'd appear in front of would really handle some of those issues, and we would train them on those kinds of things. So it's that sort of thing that I think the legal services organizations would have more of the burden to create. But still could do it as a community if there was a group of community justice workers, say, all doing like housing work as part of Stay Housed LA or something like that. So I think it also would create some consistency, especially for topics like the ethical provision of services, if we had some broader, sort of a more broadly applicable training. And then legal services organizations would also have the burden of obtaining client consent, controlling client files, malpractice insurance, just like they do currently with staff and any volunteers. So, you know, all those sorts of kind of, you know, ethical parts of practice and practical parts of it would still fall on the legal services organizations to have that set forth before kind of going through their hosting a community justice worker. Permitted activities. So the legal services organization, again, would submit the proposed scope of work, including the substantive topic, as well as the tasks that would be allowed for the community justice worker. So the goal, again, I think I feel like this is like a broken record at this point, but the goal is really to offer legal services organizations flexibility, right? Because one organization may want to have a community justice worker focused, like have 4 of them focused solely on immigration law. Another organization may want to have one that's working in family law, one that's working in housing law. And so each of those organizations are going to, like, by definition, have different scopes of work because the tasks are just different in those case types. There could one idea that has come up in part based on conversations that we've had would be to identify broad tasks that could be prohibited, like, for instance, court appearances, at least initially. And then we can all, you know, there's always room for adjustment going forward. But initially, that it's easier to, I think what we kind of discussed is that it's easier to identify things that couldn't be done rather than identifying the 17 million different lists of tasks that could be done and how far down do you go into detail and all of that. So the permitted activities would essentially be what the legal services organizations would like them to do up to a certain point, basically. In terms of data reporting and evaluation, I think one of the key pieces of these kinds of programs is having that information and data to show that these folks really are making a difference. So there would be some annual reporting requirements. We did in the proposal, there were some identified data points. And then nothing too different than what I think folks are already reporting for reports like IOLTA, and that the goal was to try to, you know, not create new reporting requirements. I think the main addition would be specific data points about the community justice workers themselves, taking into account any concerns about their own, you know, privacy and that sort of thing, but getting, you know, sort of an anonymous but broad understanding of who the community justice workers are, their connection to the client community. I think one of the big kind of aspects of this proposal would be hopefully bringing in more folks who are members of client communities can provide often more trauma-informed care, and just kind of creating that connection with clients. And then the proposal also calls for a more robust evaluation after a certain period of years. That period of years is still, I think it says 5 in the proposal. I think there's been discussion about whether that's too much, enough, et cetera, but we picked 5 as sort of a middle ground. And that we would, after getting some feedback from some data folks, the goal would be to identify the data points for the evaluation in advance as well. And to be as realistic as we can be. I think those of us in legal services, we all want to be able to like quantify the impact that we have on clients, but we also recognize the challenges that come with that. So I think to the extent that we can, figuring out how to really do an evaluation of the impact that the community justice workers are having on the legal services organization and even more on the client communities. And that is sort of the overview of the proposal. There's obviously, this was 4 slides and there's a lot more pages in the proposal itself, but we just wanted to kind of go broadly over the different components. And I don't know, do I pass it over to Lucy now, I believe? Let me stop sharing. Give me 1 second. Go.
Hi, everyone. My name is Lucy Rica. I'm the executive director of the Rhodey Center on the Legal Profession at Stanford Law School, and I work on these issues of sort of how to increase people's ability to get legal help and, ways of rethinking how we regulate legal services. And I've been really lucky to be a part of this working group and just help sort of figure out how to make this thing a reality. So I think my task is just to talk a little bit about the actual framework. And Lee gave a great overview of the components of the proposal. And I think just again to stress, in the course of the discussions of the working group, in the beginning the beginning half of the discussions, we had a lot of talk among the participants about different potential specific programs that, for example, Betzetic or CRLA or LAFLA would want to do. And there were so many great ideas. And so what we ended up putting forth on paper and what you all have had in front of you is a framework that is essentially a regulatory framework that allows for many different potential programs to come into existence. But the proposal itself is not a proposal for any specific program. And so that's a sort of key distinction. And I think that's why the goals that we were prioritizing was how to, as Lee said, how to enable different legal services orgs to be responsive to the needs of their community, and then also how to get to scale, how to get this huge diverse state of ours. It's quite different from Alaska. So what framework could we set up that would allow for a bunch of diverse programs to potentially come online with as little friction as possible? So that's what the proposal does. And I think what I'll talk about is sort of the key sort of regulatory components. So the first aspect would be the authorization of new programs. And in the proposal, we did not make a specific sort of plant the flag, this is what we think it should be, recommendation, but we did tentatively suggest that the Legal Services Trust Fund Commission would be the right body to perform the authorizing function. So that body would take on applications, would sort of be the body through which IOLTA orgs would present their desire to move forward with these programs. And so the kind of initial piece of the regulation, the authorization of these programs would happen with the Trust Fund Commission. And we felt that made a lot of sense for efficiency's sake, and because the folks in that group are already so immersed in legal aid organizations and what you all do and how it's done and the data that comes in and already has just such a kind of significant oversight of these programs. So that is a tentative suggestion. So far, the response has been relatively positive to that suggestion. So our hope is that that might work. I think also, the feeling is that ideally, because of the sort of fast track for IOLTA orgs, potentially that wouldn't be a significant additional heavy lift for the IOLTA Commission, but that sort of remains to be seen about the interest related to the interest of non-IOLTA orgs to develop programs. And the one key there is that we do think that it would likely require some statutory adjustment. So, I'll talk at the end a little bit more about the policy approach here, but we do think that it's likely that we would need a bill that kind of assertively, proactively says that the IOLTA Commission can do this kind of work. So that's part one. Then in terms of ongoing oversight and monitoring and sort of the back end enforcement function, I think what's really great about this proposal, which Lee touched on, is that it puts a lot of the responsibility and agency in the hands of legal services organizations themselves. This is not an independent licensing program. CJWs are not going to have a license to practice law. Their ability to perform these activities and to provide these services is entirely contingent upon their affiliation with a legal services organization that itself has received authorization to do this. So in that way, it's kind of similar to the accredited recognized organizations framework at the federal level in immigration. And it really, it's quite effective, I think, because it leverages the structure of the organization and the institutional status of the legal services organization to allow for quickly scaling and quickly bringing online a number of individual CJW providers under the umbrella of that organization, and then uses the limits of that organization's affiliation to set parameters around what the CJWs can and can't do and when they have to terminate their performance. And it also puts the front lines in terms of enforcement on organizations themselves. So, for example, if there are problems with any individual CJW, whether those problems are any sort of malintent or just kind of inability to do the work well, the initial onus is on the legal services orgs to, as you would with any volunteer or any staff member that wasn't performing, to intervene and address, including, if it's not working, termination of that employee through or termination of that affiliation if it's a volunteer. And that termination would effectively remove the CJW from the ability to provide those services. The bar does play a role in sort of a information holder role. So each legal services organization would have to kind of submit their program scope to the bar. The bar would maintain a roster of these CJW programs publicly and would maintain a roster of individual CJWs. In the proposal, we didn't necessarily require that the roster of individual CJWs be public because oftentimes there's kind of a high turnover. And so, but that could be on the table as well. And then the bar is also responsible for communicating any termination of CJW status to the relevant UPL authority. So in this case, the district attorney's offices and whatnot, because once those folks are no longer authorized, then if they're continuing to provide any legal services, then they fall under UPL enforcement. So that's the quick rundown there. One other piece on the evaluative function. Again, we didn't kind of plant a flag on this in the proposal, but we suggested that the Access to Justice Commission would be an appropriate body for overseeing the evaluation of this project. And we presented at the Access to Justice Commission a week or two ago. And the response was quite positive. And, again, I don't know what they're going to end up planning to do there, but for now, that is what the proposal says. I think there's other places that could also perform that function. So just really quick, a couple of other additional things. To be quite clear, this program is a proposal for community justice workers who would be able to perform limited practice of law services. So it is a program that creates a safe harbor from UPL enforcement or provides a waiver from UPL or from the unauthorized practice of law ban for CJWs providing, the approved services under the program. So it would enable CJWs to do limited legal advice, helping people answer a notice of eviction or what have you. But whatever additional sort of limited services. And as Lee said, there could be a cap on where those how the range of services that legal services orgs could propose, or not. But most likely these are going to be relatively routinized, straightforward legal services, including legal advice and assistance with completing forms and writing letters and drafting documents and that sort of thing. Perhaps some negotiation assistance as well. The proposal does not include a waiver of Rule of Professional Conduct 5.3, which is the rule that sets out our responsibilities in supervision of non-lawyers. And that's important because it performs a number of functions, right? It retains, again, it sort of shores up the legal services org's role in terms of supervising and ensuring competency of these justice workers working within and affiliated with their orgs. And it also sort of performs the work of ensuring that we retain the agency relationship between the legal services orgs and these volunteers so that the things like the attorney-client privilege protection and work product protection can extend to those relationships. So that's an important key sort of legal point to think about, is that there is a UPL waiver within this proposal. There is not a 5.3 waiver. So supervisory duties of the legal services orgs are retained intact as they are now. So maybe I'll stop there, and I think I'm going to hand it off to Diego and Jessica Jewell if she's on, which I'm not sure if she's on, to talk about their individual ideas. Oh, she is. Yeah.
Jessica is here and up next. Thank you, Lucy, Sasha, and Lee. That was very thorough. Okay, Jessica, I'm going to make you a co-host.
Sounds good. Okay, so I do have a couple of slides to share with you all. Let's see if that works. Can you see this?
Yes.
Great. Okay, so thanks, Lucy. Thanks, Zach, for having me. It was a real honor to be part of the committee that worked on this and share some thoughts. So I was asked to join this call to be able to share with all of you a little bit about what we are already doing at CRLA. And so this definitely influenced my feedback and comments on the committee. And I think it could be a place for folks on the call to just start thinking about some of these ideas and how this could be used. And then I guess I should back up and introduce myself. So my name is Jessica Manriquez Jewell. I'm the president and CEO at CRLA, California Rural Legal Assistance, Inc. I use she, her pronouns. I've been with CRLA for over 16 years. And fun fact that I always love to mention, especially in these conversations, is that I actually started at CRLA as a community worker. So I had the chance to firsthand experience of some of the work that our CWs are doing every day. And so obviously I'm a big believer in this model and the work that can be done by non-attorneys. And so at CRLA, for those of you that don't know, our mission is to dismantle unjust systems through community lawyering, and we're working towards this vision of a just and equitable world where all communities prosper. So as it's implied in our mission, community lawyering and engaging in the community is a huge part of the work that we do and the way that we approach the work. So we, from the beginning of our organization, have had community workers. We call them CWs. So just to share a little bit about CWs at CRLA, and this is actually one of our amazing CWs, Diana, down in Delano, our Delano office. And so, like I said, it's been part of our model since the beginning, since 1966 when we were founded. The community workers are employees of CRLA, and since the outset, the goal of recruiting CWs has been to recruit people that can be bringing, that lived experience, helping to build trust with the community, and helping bridge language and cultural barriers. And so to really be able to help CRLA embed itself in the communities that we're serving and bring up community members into the social justice space and into providing services to their own community. And so CWs handle a variety of different tasks. They do, the traditional outreach, know your rights work, but they're also doing a lot of case handling. So they're helping with intake, they're helping with document preparation, they're helping with litigation support, and many times they're leading cases on some of those shorter, counsel and advice kinds of cases. So they do a lot of work already that is contemplated under this model, but right now it's under the strict supervision of an attorney and having to, check with the attorney at every single point, have the attorney review everything that's produced by the community workers. And so another big piece of our work is, in addition to the community workers, is using community leadership as a tool. And so trying to amplify existing community power through the work of comités, which are our advisory committees. So on the left is a photo of some of our comité members who are community leaders and serve as advisory group members for CRLA. And then on the right is a picture of one of our group clients. So it's a group that has formed that has brought on CRLA to advise them and work on a legal issue that they have. And so both of these models are working with community members who are already organizing in their community, showing leadership in their community, doing advocacy work in their own right in their community, and CRLA works with them to help move that forward. But this is another space where we really see this model being able to benefit us. So what's possible with that in mind? We are really seeing this as an opportunity to expand legal advocacy, expand what our current community workers can do, potentially having them be able to do more, having them be able to take more of a leadership role in these cases, and really being able to scale up our existing model. I also see this as an opportunity for a career opportunity for like growth and professional development for non-attorneys. And so really the existing model that we already have, scaling up and be able to do more with the limited resources that we have. And then another really exciting part of this is being able to expand the model to external community justice workers. So I mentioned our comité, I mentioned the client groups that we're working with already. We also have, like many other legal aid providers, we have a number of partners, community partners, where we're doing know your rights presentations or other sorts of partnerships where this would allow us the opportunity to train them up, bring them on as community justice workers, and more along the lines of our pro bono attorney models, where we can just expand the number of people who are out in the community being able to provide legal services. And the fact that we're in a lot of rural spaces, that piece in particular is very exciting for us because we really want to be able to meet the community where they are. That's the whole concept behind our community worker model already, but being able to expand that and being able to tap into other leaders and other folks in the community who are already trusted and can just grow that ecosystem of folks that can help advocate for the rights of others. So I will pause there and happy to address questions at the end, I guess. But let me know if there's anything else you were thinking of, Zach.
That's perfect. Thank you so much, Jessica. Let's go to Diego now. Hey, Diego.
Hey folks, good afternoon. And apologies in advance. I've been having some internet. Zach, you can let me know if something goes awry. But I'm Diego Cartagena. I'm the president and CEO of Bedside Legal Services. We provide free services to low-income individuals across LA County, focusing on areas of economic justice, housing and homelessness, children and family, and elder justice. And prior to the pandemic, we had to explore the possibility of kind of one step in the direction of a community justice worker model through our employment rights program. So a lot of people know this, and I actually have to go back, I guess, and correct the record from the presentation at the Access to Justice Commission, because I said that every single week in Los Angeles, there are $23 million worth of wages that are stolen primarily from low-wage workers. The number is actually 26 million, so it's not a great correction to have to make. But nevertheless, the number is really startling, and our rights team, which is a staff of about 5 individuals, works day in and day out very, very hard to try and combat wage theft. But as you can imagine, there is only so much that we can do. And so the employment rights team, we refer to them as ERP. The ERP team, they have the idea of working with many of the worker centers here in Los Angeles, which we already have great relationships with, to establish a training for their staff that would also be open to some of the workers that have experienced wage theft and have been through the labor commissioner process to advocate for wages being paid when they've been stolen. Train them in what goes into a wage claim before the labor commissioner, how to prepare and file the claim, and how to prepare and advocate for themselves at the labor commissioner hearing. Now, as I mentioned before, this is one step in the community justice worker model. And maybe not quite the same step that is envisioned by this proposal, because this proposal really talks about people stepping into roles where you may be liable for the unauthorized practice of law if, for example, you are at counsel table helping make arguments before a bench officer. But in labor commissioner hearings, you don't have to be an attorney to advocate. But here's the important thing. The distinction is that bright line as to giving legal information and giving legal advice, right? So we can teach someone all about the labor commissioner process, but there is a danger there that one could cross over into the field of unauthorized practice of law if, let's say, someone at a worker center or a fellow worker, when they're working that has had wages stolen from them, they start giving legal advice when an issue comes up, like whether or not someone is an independent contractor or an employee, which is a very hot topic. It's usually a line of defense that employers will make in matters. And so it can get very tricky when you're analyzing that and giving advice to someone as to how to respond to that defense. And so this model would create the infrastructure that this can be taken that a step, right, with the appropriate training and oversight of attorneys like we have at our employment rights team at Pathetic. They could be providing that level of guidance and providing that training to people who are not apathetic, but rather they are employees of these other agencies and therefore have a multiplier effect out in the community, so that hopefully more people are able to successfully bring these cases and get the wages that they are owed paid to them. And I apologize, I don't know who is next. Otherwise, I'd turn it over.
That's perfect. Thank you, Diego. So we're going to move into I believe the Q&A portion now. So I'm going to spotlight everybody again, and then we can, have folks get on stack, unmute, whatever works. So here we go. take it away, Sasha, I think.
Okay, great. So thank you all, and Diego and Jessica, especially thanks to you for making it come to life a little bit and help us imagine what these things can look like. Like Lucy and Lee mentioned, there are lots of different ways to do this, but when you hear the creativity and what organizations might do and how different that might look, and how all of you in the room, your organizations have the expertise to figure out what is needed, who the right community partners are, and what those trainings and services might look like. We're really excited to see what can come from that. So we're going to open it up to questions, and we have plenty of time to both answer questions about the proposal itself and like someone mentioned, we are in feedback mode. So this is just an initial proposal. We want to hear from you all. If you have concerns about something or this raises questions, please tell us. We are taking notes. We are going to be revising. So we want to answer questions about the proposal. We'd also love to hear from you all about any ideas or projects that you would like to see stood up at your organization or elsewhere. And I'll also share at some point a Google form. We'd love to hear if your organization already feels like they can say, yes, we support this and want to be part of the effort, or if your organization wants to learn more. We will be doing continued outreach as we build for making this a reality. So I will start with hands. Thank you, Millie. Go ahead. Millie, are you able to come off mute? Okay, I don't know how this works.
Might have been an accident.
Nope, I'm sorry. I'm on my phone and I couldn't find the mute button.
Okay,
great. Yeah, so I practice primarily immigration, and we're looking at DOJ accreditation. Is this something that could like overlap with DOJ accredited reps? Like we could have them be a CJW and they're DOJ accredited and basically kind of in line with both programs?
Yes, because under this program, the attorneys retain supervision. So in different forms, right? Supervision can look lots of different ways, but attorneys retain supervision, just like you would a new attorney or just like you would a paralegal. But folks are able to give legal advice who are not typically able to. It could be overlapping, it could be distinct from, and it could certainly cross into the immigration space. So it wouldn't, you wouldn't be required to have a DOJ rep, wouldn't necessarily be required to have CJW status to do what they're already doing. But if it was something additional, or if it was someone who didn't have a, wasn't a DOJ rep, they could.
Yeah, and for fully accredited reps, they actually can appear in court. Would that be like prohibited from this? Because you mentioned in the slides that, court appearances aren't something they'd be able to do.
Great question. No, anything that's authorized now remains authorized. This is just an additional path to allow folks to provide services. And
I will say the mention of that court appearance thing was like a hypothetical, right? Like it is a potential that we could, that depending on how negotiations go and legislation goes, that we could create a list of prohibited activities, but there's also the possibility that we allow the organizations to determine what those activities are. And I mean, ideally, I would say if you're to have an accredited rep, you'd want the kind of the ability to perform the tasks to overlap. I will also say that we worked on this proposal before the election. And so that's largely why immigration wasn't a huge focus, because we were like, oh, there's an accredited reps program. Like, why do we need to worry about it? Obviously, it's a little different now. And there's been a lot of folks who are practicing immigration who are thinking about this as a potential substitute, kind of additional source of support and resources, depending on what happens with accredited reps, and also just to kind of help accommodate the additional needs. So I think that conversation has moved. Like had we known, could we have seen the future, we might have moved more to had more discussions around immigration and the crossover with accredited reps. But again, this is just a proposal. So like, we can have those conversations now and adjust and adapt.
Yeah. And I think we plan on adding in some immigration examples in the next round. And also, just to clarify too, the only things in the current proposal that are off the table for CJWs are fees, obtaining fees for work.
And I think serving the clients of like the income limitations limited to whatever the organization is.
Right. They have to be folks who would otherwise qualify for your organization.
Yeah.
Exactly. Thank you, Millie. Good questions. Angela.
Yes, I just wanted to make sure that I understand properly. So our community justice workers, is your vision of that to be limited to, different professional groups such as social workers, or is this to be open to anybody of any background, any profession, any training or ability that is interested in working in the program?
I think how we've structured it is that the organizations can determine who the right community partners are. And so there are no limitations in the proposal currently as to who that is. Each organization will, as we've seen across the country, as folks have built out these programs, will undoubtedly work to find community partners that are working in a similar space, like the ones Diego mentioned, who are at worker centers and are already doing a lot of that work and just might benefit from that additional training and support and the UPL waivers. They can actually give the advice that they've been trained on. And so likely they will be community partners who are consistent with the program that is built out such that the work would make sense in their workflow. And it's also anticipated they could also be staff at the organizations like Jessica's, where they have community workers on staff and are able to extend there. So, and all of those things are anticipated. There aren't any current limitations on that.
If I could just add there. So Alaska's Community Justice Worker Program, which is one of several across the country, but it's the one that it has reached scale the fastest, partly because they sort of leverage the existing community health worker network, tribal community health worker network in Alaska. But that program, for example, draws community justice workers from a really wide range of folks, including tribal government staff, social services folks, other healthcare professionals, and citizen volunteers who aren't necessarily affiliated with an existing community-based organization. So, and that's one range. There's, other community justice worker programs that have maybe a more narrow scope, but I think what we tried to do, again, with this proposal was really not put any front limits on it and really defer to the organizations themselves.
Great. Anyone else have questions?
I had a question.
Yeah.
I was curious whether or not, and I apologize if I missed this distinction, whether these community justice workers would, one, be employees of the IOLTA program, and then coming off of that, whether they would then fall under the attorney-client privilege, and separately, whether or not they'd be mandated reporters. Just based on perhaps their other employment. I know that there's already programs that have social workers that as a legal organization have come to conclusions about that, but to the extent any of these folks might also be medical providers or attached to medical services or something like that, how that may have be a part of the proposal in some way or another.
I can kick this off and I'll pass it to someone else, but in the big picture is that the justice workers could be either employees or non-employees. We didn't determine that. I think just like Lucy mentioned, the scale issue is you're scaling more if you are working with folks who are allied professionals in partner organizations who are already doing this work and want to do more. And you're not, of course, bringing on all those folks as full-time staff to your organization. But it is anticipated that it could be either. And attorney-client privilege and all of those rules would attach. They would be volunteers, just like a pro bono attorney is a volunteer for your organization, or a legal assistant that works on a case. All of it would attach to the folks, and all of the ethical rules would attach. Lucy, let me pass to you to talk a little bit more about the details there.
Yeah, so I think the question of sort of competing disclosure versus privilege is kind of an outstanding question. So my sense is that it perhaps is best dealt with, again, at the individual org level in terms of sort of an agreement, and then it's up to the organization to sort of make that disclosure upfront with the client. And there is an informed consent aspect also as a requirement as well for clients opting to use CJW resources. But we don't have anything in the proposal specifically saying that, the attorney-client privilege would take precedence over competing disclosures. That's something that we certainly could consider including.
I think it may also, I just want to add in, I think that may also come down to how legal services orgs decide who they bring on as community justice workers. And so, I think when legal services orgs have social workers in-house, they talk to the social workers about that they are an agent of the attorney at that point. And I don't know, honestly, like just ethically from the social worker side, like that might be a question to ask, but can they switch back and forth? That doesn't feel right to me. But that's a gut feeling, not an actual like legal opinion. And so I think that might be something like if I were determining like who I wanted to partner with as a legal services organization to bring on community justice workers, I think I would take that into serious consideration.
Great question, and we are taking notes on that. It has come up, and we will think about how to address that.
Sorry, I did want to just say one more thing though on the confidentiality piece generally, that would apply the same way like your volunteers, right? Like if you have a law student volunteering with you, that piece of it, even if they're not an employee, there's still that privilege that would apply.
Thank you. Other questions? These are good ones. And if you have feedback, not questions, you like something, you don't like something, you think we need more on something, feel free to share that with us now.
Sasha, while we wait for the next question, if I can chime in on a related
please.
topic but in the other direction, because we've been talking about partners in professional settings. I just want to like amplify again the opportunity that this would create to bring on partners. I think you call them Lucy citizen volunteers. So just folks in the community, that this could really be a path to recruit and just get engagement from community members in the social justice space, and really being able to develop these skills in community members. I think that's one of the other really great things about this model, that it would allow us to invest in the communities that we're serving and invest in the people in these communities and just create that leadership opportunity for others, even if they're not currently in a professional setting or don't necessarily have the traditional educational background that you see in firms and in the social justice organizations.
Absolutely. Thank you, Jessica.
I have a comment regarding the privilege and the mandated reporters. We've been providing technical assistance for some other agencies who are accrediting representatives to do immigration work. And the state bar didn't have an answer whether or not it's ethical for an advocate who falls under the rules of social workers and having to be mandated reporters also wearing the hat of a DOJ accredited rep. The state bar didn't have an answer. They said it should be okay. However, in our discussions with the other agencies that we're working with, we felt that there should be some firewall between an advocate versus a DOJ accredited rep, just because the privilege and what we can share is very different than what mandated reporters have to share. And so having to switch on and off that hat without some sort of firewall is a very dangerous line to tread. And so one of the agencies that's developing their DOJ accredited rep decided against having somebody that wears both hats because of that reason, for the ethical reasons. And they didn't have a surefire way of firewalling the client base between the social workers or the advocates versus the DOJ accredited reps.
Thank you for that. That's really helpful feedback. And maybe if you all have anything written up, or if we could follow up with you to talk more about that, I think that would be really helpful.
Yeah, sure. I can connect with you, no problem.
Okay, terrific. Thank you. Great. Well, I know folks are going to be jumping off soon. We're happy to stay on, take more questions. I'm going to put this Google form in the chat. If you are interested in supporting the effort, staying in touch, learning more, giving us feedback, talking to us, please fill it out and give us your information. We are, again, in feedback mode and would love to hear from all, and are especially interested if any of you have ideas about programs that you'd like to run. Any other questions? All right.
Hi, this
Beth.
is
Oh, go ahead.
Beatrice with the Office of Clients' Rights, Disability Rights California. Just wanted to get a bit of a clarification over, the fact that this is not a 5.3 waiver. And so, all of those requirements would still apply. And I just wanted to know, when talking about, a licensed attorney, supervising, these community justice workers, does that also mean supervising all of the work products? So let's say they're, now they have the capacity, right, to give some advice, but they're going to send out a letter with further advice or information. That must still, right, currently be reviewed. So we're not, relaxing any of those requirements, correct? Through this proposal.
So the proposal allows, Lucy and Lee, jump in here. The proposal allows attorneys to treat the CJWs just as they would someone who is allowed to give legal advice with the right supervision under their direction. So just like you would, say, a pro bono attorney who doesn't know the subject matter and you're training them up, maybe the first time you're reviewing and you see the letter before it goes out. But after the first couple of times that you're letting them do it on their own, they're authorized to give that advice with the right or take an independent action with the right training and support. So it would be on that same kind of continuum. You still have the 5.3 is still in place. The attorney still has the obligation around supervision, but the individual has the capacity to move toward independence on those things.
Yeah, I think that's right. I mean, I think what's really interesting about this is that it's sort of like this intersection between UPL and then 5.3. And 5.3 is actually pretty, it's a principles rule. There's not specific requirements written into the rule. It's really a reasonableness standard. So you have to give reasonable supervision given the kind of capacity, competency, training type of work. And I think what the way Sasha described it is exactly right. That this program allows for more capacity and competency on the practice side so that the supervision doesn't necessarily have to be to still satisfy that reasonableness standard. The supervision doesn't necessarily have to be as intensive as it has been when the person is not allowed to be trained up to do these things.
Okay, thank you.
Thanks for the question. And we are working to include more in our FAQ about those kinds of questions, because you're not alone in asking that. Folks are trying to figure out what that looks like and how this works. So
okay, we're at the 1 hour mark. Thank you so much to all of our panelists, and thank you everyone for being here.